In a historic ruling, the Supreme Court recently declared that former President Donald Trump cannot be removed from the ballot in Colorado or any other state. This unanimous decision brushed aside claims that Trump disqualified himself under the 14th Amendment's insurrectionist ban. Let's delve into the intricacies of this significant ruling and its far-reaching consequences. To understand the gravity of the Skotis decision, we must first revisit the Colorado court's initial determination. The state court argued that Trump engaged in an insurrection due to his remarks before the 2021 attack on the U.S. Capitol, violating Section 3 of the 14th Amendment and rendering him ineligible for the state's ballot. Similar actions were taken by Maine and Illinois, aiming to exclude Trump. However, the Supreme Court's recent decision overturned Colorado's ruling, asserting that states lack the constitutional power to enforce Section 3 concerning federal offices, especially the presidency. The Supreme Court's unanimous verdict. The High Court unequivocally stated that states cannot remove a federal candidate, especially a president, from the ballot based on the insurrectionist ban. According to the court's unsigned opinion, it is Congress, not individual states, that possesses the authority to enforce this provision. This declaration has implications that extend far beyond Colorado, putting an end to potential similar lawsuits nationwide. Impact beyond Colorado. The court's decision holds immense implications nationwide, preventing any state from overstepping its authority in attempting to remove Trump from the ballot. This victory for Trump not only secures his position as a frontrunner for the GOP nomination, but also eliminates a legal threat that had loomed over his potential second term. Victory for Trump. The court's opinion not only shuts down state enforcement of the insurrectionist ban, but also raises barriers to its federal enforcement. However, this unity within the court fractures when it comes to the extent of limiting federal enforcement. 4 justices, including conservative Amy Coney Barrett, and 3 liberal justices, argue that their colleagues went too far in restricting potential federal enforcement avenues. Dissent among the justices. This dissent raises concerns about a potential confrontation in Congress during the 2025 electoral vote count. The court's opinion leaves unanswered questions about whether lawmakers opposed to Trump could attempt to disqualify him after the election, adding a layer of complexity to an already sensitive issue. Future challenges. Despite the court's avoidance of directly addressing whether Trump's actions on January 6 qualify as an insurrection, legal experts predicted such a narrow ruling. The decision, while technically allowing Trump back on the ballot, falls short of exonerating him, as pointed out by the liberal watchdog group Citizens for Responsibility and Ethics in Washington. Citizens for Responsibility and Ethics in Washington statement. In a statement, Noah Bookbinder, the president of the group, emphasized that the Supreme Court's decision was on technical legal grounds, not a vindication of Trump. The missed opportunity to exonerate Trump is a significant critique, highlighting the complexity of the legal arguments involved. Amy Coney Barrett, in her concurrence, urged unity despite the dissent among the justices. She stressed the importance of the court's unanimity in settling a politically charged issue during a presidential election season. Barrett's call for a de-escalation of political tension underscores the delicate nature of the case and its potential impact on public perception. Public opinion on the Supreme Court appears lukewarm, with recent poll numbers indicating a 40% approval rating. The court's involvement in high-profile Trump-related cases, including the Colorado dispute, may have contributed to this tepid reception.